All right. So everyone should see that we proudly present till death or divorce do us part, the terms, guidelines, and issues you need to know. Just one quick little commercial. If you're not already aware of our Start in Here mobile deposit, it's a great way to save your clients a trip on your sale transactions to our office. They can just take a picture of the check and have that to us electronically very quickly. For our realtor clients, we also have our In Here desktop program and app that allows people to keep an eye on their transactions as well as get notifications on certain milestones. And with that, I am going to turn it over to Stephanie Dimmick.
Good morning.
And again, if you have not muted your microphone and could, that would be greatly appreciated.
Morning, everybody. So we're going to talk about death or divorce in an escrow transaction. And we have a lot of different scenarios that we're going to go over. I'm going to tell some stories that I've experienced on some files. And I just want to say I have been doing this for a little over 20 years, and still there's new situations that come up that we've never experienced before dealing with these two topics. So we'll try to cover some different scenarios, but you never know exactly how it's going to play out. Always just want to have a conversation with your escrow officer from the beginning if you know that either one of those situations apply to your transaction. So, and that's what this slide is saying. We just want to prepare and train you, if nothing else, for this class to have a conversation, because if somebody that holds title to the property is separated, divorced, or deceased, it's going to take time and additional documentation to make sure the escrow closes and nothing comes back to haunt you from any beneficiaries or potential heirs. So this is even true for a buyer that's still married. So if you don't learn anything else today, just learn this tip. For every listing, pull the current vesting deed, so that when you meet with the seller, if their name doesn't match the name of the person on title, you can find out why and contact your escrow officer to look into that from the beginning to figure out what steps need to be taken to remedy that. What to expect when you're divorcing. So there's 4 potential scenarios that we're going to talk about today. The first one is the clients are just separated, not legally, but just not still acting like they're married to each other. They're just separated. The second is they're legally separated. Next one is going to be the divorce is filed but not finalized. And then the last one is the divorce is final. So we're going to jump into each of those separately to talk about what's needed and how we treat those. So first one, just separated, but not legally. Well, as you can imagine, we're going to treat that just like they're actually still married, follow all of the customary practices. So if you have a buyer that's separated but still legally married, we're going to need to have their spouse execute an interspousal deed in order to not be listed as an owner on the property. So they're going to still need to cooperate and sign, and sometimes they're not interested in cooperating because they've just decided to separate and they don't want to be friends anymore. So the sooner we know in a transaction that that's the situation, the better. Oftentimes I'll have a file be opened and the agent or lender will say, hey, heads up, John Smith is going to go on title by himself and his wife, Jane, they're separated. Can we reach out and have her sign a spousal deed early in the transaction? 100%. We'll prepare that document. We'll reach out to her and have it signed. Sometimes Jane doesn't want to sign it right away. She's mad because John hasn't, completely agreed to what the terms of their soon to be divorce is going to be. So those things can take time to be resolved and signed for the file. So the sooner we know, the better, so that we have enough leeway to get working on that. Sometimes the client will want to sign that with their divorce attorney. That's fine. We can send the document there too. In the situation of a seller, both parties are going to need to sign all of the sale and escrow documents. So legal separation, or not legal, sorry, just separated, not legally. Basically, they're still married. We treat it like that. Next one is legal separation. really we're going to treat it the same way too, that they're still married. The only difference with this one is that we're going to address any liens that might be present in the file. So for example, like if they filed court documents that they're legally separated, what if the husband went out and racked up like some additional credit card debt and there's a judgment against just him? Then there might be some reason that they want to discuss he should be paying for that from his proceeds rather than the wife. Those are situations that we would need to address, have instruction and guidance from any attorneys involved. We're still going to need to have any grant deeds signed, either case, buyer or seller. If it's a buyer, then they're going to need to have a spousal deed signed for the spouse that's not going to be taking title with them. And then for a seller, same thing, they're both going to need to sign all the documents. One situation that's different that we would be able to close without the soon-to-be ex to sign is if it's an all-cash transaction. Even in that situation, the buyer can choose to hold title instead of married, sole, and separate. We can close with an instruction signed by them as just either a married man or a married woman. But the caveat to that is that they're going to sign an instruction that says that they acknowledge that the spousal interest is still going to need to be addressed at a later date, either whenever they go to sell that property or refinance it, then that spouse would need to deed out at that time. And in delaying having that spouse sign off, what if that person is out, has some bad debt that becomes a judgment or a lien? That entire time that they haven't deeded out gives more time for those liens to attach to that property when they do have to deed out, and title would have to check for those. So even though it's possible to close without the deed being signed by the spouse on a cash transaction, probably a good idea to not delay it because you open yourself up to those future problems. But it is possible.
I think I'm gonna take this in the bathroom and listen to it while I shower.
Okay, next one is divorce has been filed but not finalized. So in this situation, we're going to work with the parties, determine filing dates, things like that, that are going to affect any liens that are recorded. Again, like we talked about, who's going to pay what. Deed execution, still have to have a deed signed. If you notice, in every single one of these situations, we still need to have a deed signed by the parties. So just because you're going through a divorce doesn't mean that having the divorce finalized or in process means that a deed does not need to still be signed by the parties. The part that it gets tricky on this one is that if it's filed but not finalized, this is where we start having a conversation with the sellers about the disbursement of proceeds. How are they going to be split? When we get to this point, sometimes the parties are agreeing, okay, we're just going to split it 50-50. Sometimes a little bit of arguments start to come up. Well, I paid the house payment, so I should be reimbursed for that. We don't want to get in the middle of that. We're the escrow holder. We just want to disperse the funds. So some things that have happened in the past. I had a file that the husband and wife were trying to just file all the paperwork themselves. They didn't really have an attorney working with them, but they were disagreeing about how the proceeds were going to be split. So our answer to them was either you come to an agreement, sign an instruction by both of you of how those funds are going to be split, or we're just going to cut one check payable to both of you and we're going to mail it to the property address. Whoever gets there first to take it to the bank is the one that gets it. So, I mean, those are like extreme circumstances, but at that point, if they're trying to hold up the closing because of that, we're not going to just sit on those funds and wait for them to decide how they want to split the proceeds up amongst themselves. So we'll only divide them if we have a mutually signed instruction by both of them. If there's documents from the court that says how the funds are going to be split, we can act on those. But one thing that we often do is we'll cut a check payable to one of the parties' attorneys for them to hold in a trust account until such time as the divorce is completely finalized and they know how the funds are going to be split. Even in that situation, though, we still have to have both sellers sign an instruction to approve the funds being paid to that trust account. And I've had files that then there's an argument, well, I don't want it going to the wife's attorney's trust account because I don't trust them, and she didn't want it to go to the husband, so they had to work that out. Eventually it went to one of the attorney's trust accounts. Next one is the divorce is finalized. This is the situation when, as a buyer, we don't need to involve the other spouse at all. If the divorce is finalized, we can vest them as an unmarried man or woman and move on from there. For a seller, we can use that divorce decree as a reference, but it doesn't mean that we still don't need to have the other person sign off on the file. So I had a file close earlier this year where the husband and wife had actually finalized their divorce years before the house was sold. The husband just kind of walked away from the house, moved away, was living in another state, and then the wife decided to sell the property. We still had to involve him to sign the documents for the file. In all that time, he had several different liens and judgments that had recorded against the property because he was still listed as an owner of record that we had to pay off through the transaction. I think it was almost $45,000 in liens that were against him, not her, that had to be paid. He didn't receive any proceeds from the sale because the divorce documents showed that the wife was to receive the property in full from the divorce, but she still had to deal with paying all of those judgments off through the escrow before receiving those proceeds. So just because it's finalized doesn't mean that that problem has gone away. And so I would say that in that situation, it's best to continue to work with the attorney to compel that now ex to sign the deed at that time to be recorded. Sometimes we ask for divorce documents for various reasons. Oftentimes families will transfer properties to kids or other family members without the benefit of title insurance. And we refer to those deeds as uninsured deeds. When one of those shows up in the title chain, we have to go back and look at that document. We have to see who prepared it, when was it recorded. We compare the signatures because essentially for us to close on the transaction at that time and issue title insurance, we're going back and insuring that deed. So most of the time, when there's an uninsured deed, we go back to ask the person that signed it at that time to sign what's called an uninsured deed affidavit. And it's just an extra layer of protection for our file to make sure everything was transferred appropriately. There's no outstanding funds that were due to that individual, and just allows us to move on. Well, a lot of times that uninsured deed is the result of a divorce where the parties prepare and record their own grant deed to remove a spouse or a former spouse from title. And so we will say, hey, we need, this person to sign an uninsured deed affidavit, and people get upset. They're like, no, that's my ex. They're not involved in this at all. I don't want to reach out to them. If that's the situation, we'll ask to see copies of the divorce document so that we can verify that, yes, in fact, the property was distributed to the person that remains on title, and then we can clear the condition with that. The other thing that has come up before is I had a file where the parents had deeded the property to their daughter, and they didn't reference on that deed that it was a gift transfer. And the reason that matters is because the way the title company looks at that is if that it's a gift transfer and the person that received the property was married at the time, then we don't have to deal with spousal interest because it was a gift deed. But if they don't put verbiage on that it was a gift deed, then we have to go back and say, were you married at the time that you acquired this property? And if so, that person has to sign a spousal deed to relinquish their interest. Well, that happened on a file. It's happened on several files in my years. Most recently, the lady was married at the time, and that husband had disappeared. She didn't even know where he was. He had left the country. She had no way of getting in contact with him at all. And what could have been a roadblock ended up not being, because we were able to take that scenario to our underwriting department and showed the documentation that she had filed for divorce. Nothing had been finalized at that time. but her parents were still living. And so they signed an affidavit that they had given that property to her as a gift, and that no consideration was paid, meaning they didn't exchange funds for that. And so in that situation, we were able to move past that potential really complicated roadblock with those steps. So just because something's, different, or it's a problem outside of the normal parameters, doesn't mean that we can't proceed. It just means that it might take extra time and other layers of approval to be able to get past that. Okay. So next, oh, there was one more, maybe one more slide. Case of the missing ex-spouse, kind of what I talked about there. Only other thing on this one is that sometimes they can seek a divorce in superior court and then have court documents recorded to remove that person's interest. I've maybe only seen that happen one time. It's not super common, but if there's a court order that removes that person's interest signed by a judge, then that will work as well. Moving on from divorce to death. It's a part of life. We deal with it a lot. Where there's a will, there's a better way. Can't tell you how many times I've gotten a phone call that says, I'm getting ready to take a listing, so-and-so's mom just died. She has a will that says the son was supposed to get the property. Can we go ahead and open escrow for the son to sell it? My first question is, how was mom entitled to the property? And I pull a copy of the deed. It was just mom entitled by herself. No trust, no one else was joint tenants with her. So the answer is no, we can't just move on with the son selling the property. That has to go to probate. So there's a couple different ways that a property is viewed before it goes to probate. One is intestate, which means there's no will. The other one, there is a will, but still both of those have to go to probate. When there's no will, they have to go and do a thorough search for potential heirs. They have to mail out notices, make sure that everyone's given the chance to make claim to the estate that has a right to it. And then the other one, the will, creates and states the names of the heirs, so it makes that path a little bit more clear of who they need to reach out to for approval, gives the attorney a blueprint for distribution. But it's important to know if a probate's required, it's going to take a whole lot of time. And even if there's a will, you're going to need to have probate. I had a file once where there was some, we'll call it unlawful deeding, where there was some elder abuse that had taken place and a family member had convinced the elderly owner to add them to title to the property. And then that person died, the bad guy person, and then the elderly person also passed away, and so probate was done for her. But then when the file was open and we looked through the title chain, we realized even though that person had unlawfully, added themselves to title, we couldn't just disregard their interest because they had passed away. I think they weren't in joint tenants, they were tenants in common, and that's why we had to look at it that way. They had severed the joint tenancy. And so, yeah, a file that was opened where they thought they had already done all the legwork, were ready to move forward, had to go back and be dealt with that way. I had another one similarly where a daughter had convinced the mom to add her to title. And then the mom had passed away. They did a probate for the mom, but then the remaining siblings had to essentially take the sister to court to get a judge to order her to remove her name from title, which she did. But lo and behold, she had IRS tax liens that had attached to the property. So in order for us to not have to deal with those, they had to go back to court again to get an order avoiding those liens, basically saying she wasn't supposed to ever be in title. We're treating it like that was voided, in order for us to basically ignore the fact that she had all those liens and treat it like she was never on title to begin with. So looking at your deed, you are taking a listing, you're going to ask us to pull a copy of the vesting deed. When is it straightforward to you looking at that deed if no probate is required? So if there's two people in title that are in title as joint tenants, and one of those have passed away, no probate's needed. If they're in tenants in common, and I just want to say that word because I know it sounds similar, joint tenants, tenants in common. Tenants in common is not the same thing as joint tenants because that's when you each own an undivided interest in the property. So tenants in common, you do need probate. Next one that is straightforward, no probate required, is community property with right of survivorship. You record an affidavit of death for the party that's passed away, and then the surviving spouse is able to execute all of the documents for the property. The next one is, I've seen these more often lately. It's called a revocable transfer on death deed, and it gets recorded on the property obviously before the people have passed away. And it's like parents recording this to say, when I die, I want my property to go to my two beneficiaries. Here's their names. And so that way, when they do pass away, you can revert to this document. The thing is that there's guidelines for when that goes into effect. I think it's like a 120-day waiting period from when the person passes away that the beneficiary can then move forward and sell the property. So if you find one of these on there and the beneficiary who's in title now says, I want to do a really quick closing, let's get this sold, just know 120 days from the date that the owner passed away is going to be the soonest that you can do anything. Finally, there's also no probate if the property is in a trust. If there's a trust, we follow the guidelines of the trust for who the successor trustees are, have them execute the documents. Only one time have I had a file where it was owned in a trust and there had to be some kind of a probate, and it's because everybody else that was listed as a successor trustee, the backup, the second backup, third, fourth, they all died too, and there was nobody left to be the successor trustee of this trust, so the trust had to go to probate. One and only time that I've had that happen. So what's the purpose of a probate? It's to determine who the heirs are. A judge has to review the case. The property is distributed by the court either to an administrator that's going to sell the asset, or it's distributed to the heirs themselves. It takes about a whole year to go through the probate process. The property can be transferred during that probate process when it's signed by the administrator, and the funds are always going to go to the estate. There's no such thing as a quick closing on a property that's in probate, even with a cash buyer. And always a good idea, if you know that the parties are deceased, tell us from the beginning. I've had files where it's opened and they didn't use the probate contract, and it's like we're just supposed to try to gather clues for ourselves to figure out what kind of a situation we're dealing with. If you tell us from the beginning what we're dealing with, it gives us a better chance of asking for the right things from the beginning and helping things move along a little bit quicker. I think there's some slides next that just give you like a diagram of the probate process, which I'm not going to get like super involved into because I don't do the probate process. I deal with it when it's completed, but all these different steps that it's talking about, just to give you an idea of all the many layers that have to be gone through to get to the end of it. There's petitions, there's hearings, there's notices that have to go out. Most of these things that it's listing here are all things that we're going to need to get documentation of for our file to make sure that they were completed appropriately. Who gets the money on a probate sale? The funds are going to go to the administrator or executor of the estate, and they're going to be responsible for the correct distribution of those funds to the heirs once the file is completed. We can't pay the heirs directly through the file, especially in this situation, because everything's still being finalized on the back end with the court. If it's completely cleared probate, where they've said the property can be distributed to the heirs, that means they're the owners of the property that it's been distributed to. 2 kids, 3 kids, whoever's on there, they're the ones that get the funds at closing. They don't have to be payable to the estate. Next, we're talking about trusts again. So trusts are going to spell out for us exactly what happens upon the death of a trustee of a trust. Most of the time, there's going to list who a successor trustee is. A lot of times it's 1, sometimes it's 2. I've even had ones where there's 3 successor trustees that have to act together at the same time to sign the document. So if you're dealing with someone who's a successor trustee of a trust, ask up front at the listing appointment for a copy of the trust document so you can make sure that the person that you're talking to has the full authority to sign everything. Because if there's 2 other siblings that have to be involved and they're not in agreement, then that could pose a problem and a delay. I've had files that get opened where I'm given the information for one trustee and then I ask for copies of the trust documents and find out that there's a second. Haven't had any situation where they were completely not cooperating with each other, fortunately, but definitely something that I could see happening. Recently, I had a file where I asked for copies of the trust documents and neither of the sellers that I had been in contact with were listed on the trust at all. And so I asked for documentation to show their connection to it, if there was an amendment that was missing or something that changed to add them. And I was told by the sellers that I was asking for too much information and that they preferred to work with a different title company. Okay, that's fine. But to me, that's like a big red flag. If you can't produce documentation to show that you're the right person to sell it, I don't understand that that's, you know, me asking for too much when we're the ones that are insuring the transaction. Recently, I had a file, very strange situation. I'd not come across this one before, where the trust stipulated that there was 2 successor trustees to serve if the original trustor was still living, and that if and when the trustor passed away, a different successor trustee was to serve. Well, what happened during our file, we opened escrow and it was the dad that was still living at the time. So we went through the trust and said, okay, daughter is the first successor trustee, son is the backup. Well, 2 weeks into the escrow, dad passed away. And then sister notified us, well, now I'm not the successor trustee, we follow the other one. And yes, that's exactly what the trust stipulated. There was a friend now of the dad's that was going to be the new successor trustee now that he had passed away. And so we had to proceed, revise all of our documentation to have him sign instead of the daughter. One thing I'll say is that if somebody dies in the middle of the transaction, we have to have a copy of the death certificate in order to close our file. And that particular file ended up being delayed by a few days because we didn't have enough time to get the death certificate from the health department from the county yet. I know that originally used to take a couple of weeks. When COVID started, it stretched out to more like 3 weeks, but that's something to consider. Is this something somebody has recently passed? Make sure that there's enough time to allocate for us to receive a certified copy of the death certificate for them.
Steph, we have a question in the chat, and
Yeah.
It is, what if you have a trust, you refinance your property and you did not put it back in the trust yet, and then you pass? Does it have to go to probate, or can they go back to the trust that it should have been in?
That's a great question. It was actually going to be one of my stories that I was going to tell too. So thank you for reminding me, because this has happened more than once and even just recently. It doesn't have to go through the full probate process, but it does need to go, the attorney does need to file paperwork with the court for the judge to basically review the trust and say, yes, there was a trust and they meant to put the property into a trust, but didn't, so they'll do a court order for that. So it won't take quite as long as a full probate, but you do still have to get court documentation to remedy that. So yeah, great question.
We have one more. Can a property in probate be foreclosed on?
I think so. I don't know. That one hasn't come up for me before, but I don't know. I would
Okay.
imagine that the
Okay.
probate wouldn't stop that.
So the estate should keep up with the mortgage payments while they're going through probate.
Or
And
at least
Larry Shrimp
communicate.
is chiming in and saying, yes, it can. So,
Yeah, I mean, I would imagine you could have a conversation with the mortgage company and let them know that the party has passed away and maybe they can delay the foreclosure process. But yeah, I can't imagine that would stop it.
all right.
Steph, I'm going to jump in. I have a question because I keep hearing this a lot too. And that is, if somebody takes it out of the trust to refinance it and then they try to put it back in, obviously they have to go and record that. But some people have been explaining to me, yeah, but you took a loan in your own name, not in the trust name. The
Right.
lender landed on the name, not the trust.
You
So are
mean-
they in violation of their loan or no?
No, because it's their trust. I mean, and when we do refinances, we will prepare the grant deed to put it back into the trust. We'll have them sign an instruction that says we're going to take it out just for the refinance and then put it back in. But I mean, it's the same thing like if you close on a house in your individual name and then you go set the trust up and put the property in your trust. No, not violating the loan.
Thank you.
You're welcome. Who gets the money when the property's in a trust and the original trustee has died? Not the beneficiaries, not from escrow anyway. We don't want to get involved in deciding who was supposed to get how much and how and when and where. We're only going to pay the funds payable to the trust. And then the successor trustee, it's their job to disperse the funds to the beneficiaries at that time. I get asked that question a lot. So just want to clear that one up.
Move on.
Steph, I'm
Moving
sorry, there's
on.
another question in there. It says, how does a TOD work?
The transfer on death deed. So they have to prepare and record that ahead of time. And then I think there's a document that has to be recorded by us at the time that it's an escrow. We attach the death certificate to it and it says, you know, yes, this person died, and pursuant to that transfer on death deed, the property is now transferred to these two people. And then we'll record our grant deed showing them as the sellers to the new buyer. Things that make it more complicated for us. Number one, no one tells us the seller is dead. I can't tell you how awkward of a conversation it is for me to call a seller and say, oh, I need to get, you know, you and your wife's contact information for your loan or your payoff. And oh, well, my wife passed away. And it's like, oh, I feel so bad when I have those kinds of conversations. So don't send us on a hunt, make us the detectives to figure out when somebody's passed away. Tell us up front. Things that complicate it is if there's missing beneficiaries on old deeds of trust. This happens a lot. Properties that have been owned in a family for years, they think they don't have any loans, and then the kids go to sell it later on after they've passed away, and there's an old deed of trust that hasn't been dealt with. That complicates things and adds a lot of extra time to the transaction. So the sooner we know what we're dealing with, the better for us to jump in and find the best solution to get past that. What happens if somebody dies during the escrow? This happens more often than you'd think. Well, I guess maybe when you've been doing it a long time, it adds up. But if somebody passes away during the transaction, as long as they've already signed all of our documents and they're the seller, then we can still proceed to close. I had a file where I think it was a cash transaction for like a vacant lot, and the sellers signed all of their paperwork on like a Tuesday. We were supposed to close on a Friday, and then Wednesday morning, like 8 a.m., the husband calls me and frantically says that his wife died. She actually committed suicide like that night, like signed her paperwork, went home and took some pills and passed away. And I was like, okay, well, I'm so sorry. And I was sorry that he felt like the first thing he had to do was call the title company, but, you know, also good to have the information. And then I get calls from all the agents. Well, what do we do? What do we do? And then I look at the file and everything's signed, everything's fine. Took it to my escrow manager. He said, yeah, we can still close. If everybody still wants to move forward and close, then we can. So we did. So that can happen. If the buyer dies prior to the close of escrow, most of the time we will cancel the file, return the funds, unless a surviving party wants to proceed and is qualified to proceed. A situation where even if paperwork is signed, we can't continue is if there's a power of attorney being used. So one time I had a file that it was ugly from the start because we were given information for a power of attorney to sign on behalf of the seller who lived in Florida, and the seller lived in Florida, and we were communicating with this person who was his like second wife. And she kept telling us that she had the power of attorney. We looked at it, fine. He can't sign due to medical reasons. Well, for us, we have to have documentation that the person's unable to sign due to medical reasons. So we told her we need a copy of a doctor's note. And she just kept delaying getting it to us, so much to the point where the buyer had already deposited her closing funds and signed her loan documents, and everybody's pushing on me to move forward and close the file. And I'm like, I can't do that. I don't have appropriate documentation. We can't talk to the seller and make sure he's okay with this. And I don't have a doctor's note that says that he can't sign. So then that was like on a Friday, and then come in on Monday, and I have an email over the weekend from the listing agent that said, oh, well, good news, the principal died, so we don't need the doctor's note anymore. And I'm like, well, no, that's not what it means. It means that we can't do anything, because when the person who has granted the power of attorney dies, the power of attorney document dies with them. So we basically had nothing to move forward on. And honestly, I mean, looking back, it was a good thing. There were so many red flags on that transaction. The man's adult children were concerned that this woman had, you know, put him someplace and they didn't have access to him. So our file had to cancel. We had to return the buyer's funds to her. She had already signed her loan docs. She was almost ready to move into this house, and we couldn't continue. I think eventually I didn't handle the transaction when it ultimately sold, but it ended up being a probate file, and that wife was not the administrator of the estate, it was the kids. So sometimes things happen for a reason to not move forward. And while I was really felt bad for the buyer in that situation, it was not the right person that was trying to sell that house. So scary things that can be avoided with all the proper documentation from the start. And those are my death and divorce stories. Does anybody have any they've run into that they wanted to ask questions about?
We can definitely open it up if you'd like to unmute and ask Steph a question. We have, we finished early, so we have plenty of time. If you don't have the time to hang around, thank you so much for coming, and know that our class will be emailed to you as far as the recording, and also posted on our YouTube channel, Chicago Title Fresno. But now we'll open it up for questions. All right. I guess you did such a great job, Steph, that nobody has any more questions. So,
well, I hope none of you experience any of the scary stories, but just know that in these situations, it doesn't mean that it's going to be a bad transaction. We can still have a smooth escrow. Let's just work together and be a team to get to the finish line.
Definitely. And we're here from start to finish. So best wishes for a fantastic Friday, and we'll get that recording out soon. If you have any additional specific questions, don't hesitate to reach out to your Chicago Title sales exec or Stephanie Dimmick directly. Thank you so much and have a great day.